Mr. Collins, if you want to call this one to order, we'll get started. All right, great. Let's go and take roll call then. James Collins. Here. Dr. Ash. Here. Eddie Jett. Here. Alton Heathcote. I'm here. Philip Lim. Here. And Jason Carter. Here. All right. Looks like we have quorum, Chair. Unless you have any announcements, we'll just jump on into the agenda. Okay, great. We've got fresh start reviews and then application review, and that's what we have for the duration of this hour. So if you would, we'll start with the fresh start reviews. Let me get there myself. We've got two. The first one is Mr. Fontenot has a felony conviction for manslaughter in the state of Louisiana. It's also worth noting that Louisiana granted him a license after his sentence was served. And so nonetheless, though, we bring these before you. So it is subject to a fresh start review should you decide to go that route.
I think that evidently he committed this act when he was a youth, looks like in high school probably. Since that time, he served his sentence in accordance with the laws. He did acquire the degree, the supporting degree, took and passed the FE and the PE, and is a practicing engineer in other states. And I would recommend that we consider that in our decision. And I would recommend that he be allowed to have an active license in the state of Tennessee.
Right. Mm-hmm. Mm-hmm. Yeah, he's licensed in the very state for which he did his time, so that is helpful and instructive, I think. Yep. Then if that's the will of the board, that he proceed with his application. Obviously, he has to meet all the requirements and qualifications for licensure here in Tennessee. But based on that former felony conviction, we were just looking at that solely at that. That's the entire scope of our discussion this morning. So we'll just need a motion to allow him to continue in the process.
So moved.
All right, we got a motion from Mr. We got one from Heathcote, and then the second from Dr. Ash. Is that correct? Okay. All in favor, please say aye.
Aye.
Any opposed? All right, hearing none, then that will allow him to move forward. Thank you for that. All right, the next one was Mr. Hosick's application. You'll recall his, well, not application, but he's also wanting to move forward in the process, and he was deferred with a request for additional information. That was at our last meeting. You'll recall his, you've already got his letter. What we were missing was a statement regarding recidivism. That's one of those things that we can consider as a part of those elements. And then, of course, Ms. Martin will be driving this one should that we get into greater discussion on that. But you have that as well. We've got a statement from a clinical psychologist regarding the recidivism for your review, and I trust that you've already looked at that. Of course, redacted, the information that's not pertinent to his case, just what strictly needs to be within our purview and scope.
I thought we also agreed that we wanted to wait and see what the state of Ohio was what their board was going to do.
Also, I had a question on the Fresh Start Act. Is there a 5-year? What does the 5-year mean in the Fresh Start, or is even a part of it? Is there a 5-year period where it's post 5-year?
So the Fresh Start Act that's not the one that has the 5-year.
Okay.
I believe that's in the engineering statute. I don't recall exactly off the top of my head, but I can probably look it up pretty quick. But I think that traditionally, if it was outside of the 5 years, the board.
Okay.
Do you guys?
Oh.
If it's outside of the 5 years, then they delegate authority to push it through. And if it was inside the 5 years, the board wanted to review it. I believe that was more like a delegation of authority.
Yes.
Is that
correct?
Yeah. I think at some point in years past, we call it the Fresh Start Act. It's been remodeled many times. I think at some point there was like a 5-year period in there, and a lot of boards have kept that as like a delegation of authority to staff.
Okay.
But there's no longer like a specific 5-year recall in the Fresh Start Act, so much as they want you to like review each conviction and applicant and their specific experiences
Yeah,
individually.
but this is like a few months ago that this.
Yes, this
incident-
person is within the 5
Yeah,
years.
yeah.
right?
Definitely
Yeah.
within the 5 years.
And it was not one felony, but 2 felonies. I think that specifically speaks to the character and integrity of an individual. And I suppose from my perspective, it's a serious enough offense and a recent enough offense that I would have a problem authorizing licensure in the state of Tennessee to someone with this conviction.
I agree, and as a follow-up from the psychology, the last paragraph on the recommendations, along with the integrity issue, the last sentence, the last 2 sentences, there's a need to clarify the physical issues, determine likely causal elements. It would be important to determine whether physical aspects are having an impact on emotional and cognitive functions. And so that the integrity issue, the felony issue, plus that would lean me towards saying deny.
So we did this last time, but we will have to do it again. I think if the board is considering denying a license to this application based on the conviction, then we can go through the 5 factors. But what you really have to focus on as we like go through this discussion, and which you've kind of already started just now, is how does this specific conviction impact this individual's ability to practice as an engineer? So if the board wants me to go through those factors, and then you can make your
Yeah,
decision.
Laura,
after.
I would appreciate it if you would,
Sure.
just for our own edification.
Okay.
One point of clarification too, it's a renewal, so
Sorry, yes.
yeah. Thanks.
Okay, so these are the factors which are outlined in statute. So that's TCA 6276-104, and I'm looking at paragraph B4, and then these are the factors. So the first one is the relationship between the nature of the crime and the purpose of regulating the occupation, profession, business, or trade.
I would say we have documentation that it affects cognitive, and that's still questionable enough for a medical professional to note it.
Okay. Go ahead. Please.
I have a question.
Sure.
I might be slow in catching up. The Fresh Start Act, is that anybody in this category had to wait for 5 years, is that right?
So,
Before they can start clean?
that's not a Fresh Start Act requirement. I believe that is, this board has sort of
It's the rule.
delegated the authority that if it's been 5 years since I believe the conviction, at that point, usually they would tell Glenn that he can push through the application through, not push it through, but to process it through staff. Anything that is outside that 5 years, or I guess inside the 5 years, so something that happened last year, we would bring to the board for them to consider. So basically, the board has said, if it's been more than 5 years since your conviction, we're going to assume that you have moved past.
It's good, because at the end of the day, what I'm thinking is that none of us are perfect, right? If I be in his shoes, I'd like to get forgiven, and I'd like to move on my professional life. But what I think that our board we have to do a fiduciary responsibility of his professional conduct, which I'm concerned about, which I also at the same time want him to give him a chance to have a start so that he can be a better person. That's my thought.
So one of the things that the Fresh Act Start does require is if we do deny a license, if the board denies a license, I'm not denying, if the board denies a license, we do have to get them a time frame at which we would reconsider their application. So,
Laura, would you mind repeating the 5 factors affecting the decisions? What's?
I can go through all of them and then
No,
we can go.
but is it in our laws and rules?
It's in the law. It's not in the engineering statute. It is in Title 62, which encompasses the engineering statute, and it is applicable to all the regulatory boards.
And which one is it again, 62?
62-76-104. And that whole section, it's not actually called Fresh Start Act. It's titled Prior Criminal Convictions, Denial of License, Certificate, or Registration, or Refusal to Renew Notice Petition for Judicial Review, Scope of Section. It's kind of long, but a lot of that is about the process of which we would go through. So we have to let somebody know in writing we're going to deny them. We have to tell them if there's like an appeal right. We have to tell them when the board would reconsider their application. But specifically in paragraph B4, they have 5 factors. And these are the factors that a board or commission has to, or commissioner for commissioner-run programs, has to tie the criminal conviction to the applicant or the renewal applicant's ability to practice.
Okay.
So basically, we can't just say carte blanche, anybody who's caught, trying to think of innocuous, anybody who's caught selling a certain a certain drug, nobody convicted of that can be in this profession. That is sort of exactly what the law does not want you to do. What the law wants you to do is like consider the conviction, consider what it means to be an engineer, and how somebody who's convicted of this crime, how that conviction would show that they might not be able to do a good job and protect the public, I guess is the better phrase, in practicing.
Okay.
And then to consider all of these individual things.
Okay,
Right.
well, let's hear the 5.
Yeah, okay, so here are the 5. I'll read all of them, but then we'll have to go through one by one and have discussion points of each of them. The relationship between the nature of crime and the purpose of regulating the occupation, profession, business, and trade. That's 1. 2, relationship between the crime and the ability, capacity, and fitness required to perform the duties and discharge of responsibilities of the occupation, business, profession, or trade. That's 2. Number 3, any evidence of rehabilitation or treatment undertaken by the individual that might mitigate against the relationship of the crime to the occupation, profession, business, or trade. And then lastly, any applicable federal laws regarding an individual's participation in the occupation, profession, business, or trade. So we're looking at the conviction and sort of the purpose of regulating engineers and this is engineers. And then you're looking at the conviction and how it impacts the individual's ability to practice, ability, capacity, fitness, evidence of rehabilitation, and then any other federal laws, which there might be some here. So we can go through one by one.
Forward those to us too, just so that we've got them for future reference.
Sure.
That would be handy to have.
I'm happy to do that.
Going through this document, I do not see any evidence of rehabilitation.
Well, it's only recently occurred, and according to the information provided, the person is seeking and going through therapy, but that may or may not be completed. So I agree with that. I think we should probably take these one at a time, right?
Yes, but I'm just writing that down under rehabilitation, that they're seeking and going through therapy, but this has only recently happened, so there hasn't been much time. Or it doesn't
The letter also says that he was supposed to be sentenced in June.
Yeah.
Do we know what the sentence, do we have any information on what the sentencing was?
That's what I thought we were waiting Are you guys gonna wanna defer until you have that information?
I'd like to go through all
Yeah.
5 of them first.
Sure, we can start at the beginning then.
Yeah.
The relationship between the nature of the crime and the purpose of regulating the occupation, profession, business, and trade.
I'd say that's back to Eddie's point about this letter from the psychologist, that there's still ongoing thought into what caused this and cognitive function and that sort of thing.
And as far as sentencing goes, he pled guilty, so sentencing is just that, sentencing. It's not like we're he's defending himself and we're waiting to see what the outcome of that is. So that is something to consider, yeah.
Do you know what county he was?
Which one?
Do you know what county he was?
I would say, in my opinion, in this case, that would be a qualifier for not considering licensure in the state of Tennessee.
Elton, based on what you just say, if we said to qualify that, let's say we don't want to grant him for licensure, how long will we have to wait before we review his application again? What happens if he comes back next year? We need to give him a time, right? Time frame.
Yeah, I would agree. I would agree with that. Well, he hasn't completed his therapy yet, and I would think at least not until then, until he has clearance from a licensed therapist that his mental condition has recovered and he's no threat. And they've given him a low risk of recidivism, but that's not a zero risk of recidivism.
Also, if he goes to prison, he's not practicing.
No.
So, I mean, we have to wait till he serve his sentence.
I think that's why I was asking about the sentencing. That's why I was asking about the sentencing piece of it, because until we know what he's going to be required to do, by the sentence, then I think it's a little bit hard for us to determine how long we would want to postpone his license.
So the only reason I asked if you guys were going to defer until you had sentencing information is because we can wait to go through all of this until you have that, if you're going to defer until then anyway. But I'm happy to go through and have the discussion now if that's what you want to do. And then I can just read it back to you when we have the sentencing discussion or the sentencing information. But like Glenn said, the conviction is what it is what it is. He's pled guilty, so we know that he was convicted. So that's up to you.
I agree. I mean, he's already pled guilty regarding of what the sentencing requires. He's pled guilty to 2 felonies.
So that is yeah. I mean, whether or not that is persuasive to the committee is up to you. I'm fine.
The information we were waiting on primarily, obviously, sentencing is of interest, especially if you're talking about reapplication. But that's more of a process issue for purposes of fresh start. It didn't really necessarily play in. We really needed the treatment data because that's one of the elements is rehabilitation or recidivism. And so that's primarily was the missing piece for us to go through the analysis, and we have that.
Isn't a criminal conviction evidence enough to not allow licensure?
No. That's sort of specifically the point of the Fresh Start Act, that the fact that it's a conviction alone is not enough. We have to go through this discussion and show why this conviction specifically would impact. So what I have so far is for the first factor, and I try to just summarize sort of what everyone said, but protecting the public means assessing an individual's cognitive function. And we think this conviction means that their cognitive function is impaired.
And that's where the advice from the medical professional said that that's not verified and that they recommended it be tested and verified. That's my impression of that last
And
paragraph.
then we skipped the second one, but we can come back to it. And then the third one is evidence of rehabilitation. And I have, although they are seeking and going through therapy, this conviction has only recently happened. So there hasn't been much time for them to go through therapy, and the board does not yet see any true rehabilitation. So B, so the second factor is the relationship between the crime, the ability, capacity, and fitness required to perform the duties and discharge of the responsibilities of the occupation. So this is very similar to the first one, but the first one is about what is the purpose of regulating engineers? And this one is more about like what is the specific issue with this individual that we think that they should not be licensed in this profession.
Oh. I guess if you were to tie, our basic function is to protect the health, safety, and welfare of the public. And he mentions in his letter that the license is for him to help him in recovery, but that's not the purpose of the license. The license is for the public, to protect the health and safety and welfare of the public. That's the whole reason, is to let the public know that they're qualified to perform critical functions. 2 cents there.
I think for the minimum, we need to consider the fact that he is plead guilty, right, to 2 counts. And if we were to say, if the committee is comfortable, I would think that we could actually say, go through your treatment, and then come back. Maybe we don't have to come back to the committee. Maybe we can give the executive director the authority to move his application through.
I think an addendum to that would be go through your therapy and get clearance from
Yeah.
whoever your therapist is.
Yeah.
And the therapist offer the opinion that he's,
Yeah.
quote, healed in whatever framework or format that takes.
And also, he realized in his letter that he's currently not practicing as a professional engineer too. So that one part, he's realizing it. So I didn't want to kind of come along, tell him that he come back and then keep him. But I really would feel like if we can help this individual out, I believe he would be a better person. He would be a better engineer for the state of Tennessee. Thank you.
I agree with that when he's ready. If he's in jail,
Dr. Ash, would you mind just on, yeah.
I agree with that. When he's ready, he serves his sentence and he goes through his therapy.
So the Fresh Start Act specifically says we have to give them the earliest date upon which the applicant would be eligible to reapply. So I think that we could, in our communication to him, probably add that these are the qualifiers the board is going to look at, but we would still have to say we're going to look at these qualifications
2 years.
like in 2 years from now. We'll look at this, and if you've met these qualifications, we think you would be eligible. Okay.
We think 2 years, I think, and Eddie apparently agrees that 2 years would be a reasonable term. Where is he domiciled?
We're trying to get a county, so that'll be just a second. We're working on that right now. Yeah. I mean, we have, we're looking at the home address. I mean, I'm trying to keep it as general as I can.
But in the state of Tennessee?
Yes.
He's in
Okay.
Ohio.
Is he in Ohio?
At least that's where his conviction happened.
Yeah. Well, we're going to look it up. We'll tell you in a second. I know he has this conviction in Ohio, but, he's registered or was registered with us, so at this point, we're about to find out.
Shouldn't have signed his letter with PE next to his name either.
We typically, we just don't have the benefit of having his full application in front of us because he was, that wasn't really the scope, was his qualifications. He's qualified based on just the qualifications themselves, but obviously may be disqualified here in a second based on the character issue or the fresh start. So that's the determination. But yeah, we'll have that for you in just a second.
Okay.
So the last factor that we would want to discuss is any applicable federal laws regarding an individual's participation in the occupation, profession, business, or trade. And I could not think of any off the top of my head besides, I think at the last meeting, it was mentioned that to work on any building where children
Yep.
would be, you can't be on any sort of registry list, right?
Yeah.
Is that?
Hospitals may be on that.
He will be on a
too.
registry. There's no doubt about that. As a prior probation parole officer, I can tell you, he'll have a registry requirement, and he'll have mandated treatment as well as a part of his conditions of parole, at least in Tennessee. Now, this one is in Ohio, so I just got confirmation, so that may change.
Also, if there's any security clearance on any federal projects, he won't pass that,
Right. So,
those security checks.
yeah, so he's domiciled in Summit County, Ohio.
It looks like he's currently incarcerated with a release date of April of next year, 2026. Potentially he could be paroled, but that would be the end of the parole date. But right now,
I think the 2 years is a good.
it appears he's incarcerated.
2 years will.
2 years.
And Laura, when did you say he was scheduled for
April of 2026.
release or parole here?
Currently, the file says he is incarcerated and that his release date would be April of 2026, but it says release date or parole date. So I'm qualifying saying he could be released before then, but he would be on parole until that date.
All right. Looks like, as you know, everything was so recent, so we're kind of in real time collecting some of that information and plus not knowing what the committee wants or needs. But sentencing, he's got 10 months in jail. So he'll be released probably in what, like you said, April, yeah.
I think the 2 years is still a good time, and that will give him time to go through the rehabilitation, and then we can reconsider.
Yeah, I mean, he's not thinking about his application right now, so.
Yeah,
Yeah.
yeah.
Any other thoughts from the committee? So do we need to have a motion to defer this, or?
Yeah, whatever the decision of the committee was, we would certainly need, we would need a vote in that regard.
Okay.
I think I'd like to make a motion that we allow this individual to pursue licensure at a date 2 years. When was his conviction?
June 20th.
2 years post-conviction with supporting documentation from his therapist that there is full recovery and no or very low possibility of recidivism. Middle. I thought his was mostly middle. I know his parents are both physically ill. Well, yeah, he lost his hand. Yeah, I'm not sure what that was. Maybe stress or.
She said right here, you need to clarify the physical issues causing illness. Determine whether the physical aspects are having an impact on emotional and cognitive. Yeah. Just a clear.
Yeah, demonstration of both mental and physical recovery because he noted in the thing that the physical issues that he was experiencing was affecting his cognitive and mental faculties.
So I'm just gonna read through these factors just one more time.
We don't have a second yet, do we? I don't,
Second.
Got a motion from Alton Heathcote, a second from Eddie Jett, and then we'll do a roll call vote after the reading of the factors.
I just want to read through these really quick one more time. Cognitive function skills are impaired. The second factor, relationship of the crime and the ability, capacity, and fitness required to perform the duties and discharge the responsibilities of the occupation. I summarized it as the board's basic function is to protect the public. This applicant says this license will help him in his recovery, but that is not the purpose of the licensing scheme. It's to protect the public. Was there anything else I should add to that? I think that was kind of all that was said. And then any evidence of rehabilitation or treatment undertaken by the individual that would mitigate against the relationship of the crime to the occupation. I wrote, while they are seeking and going through therapy, this has only recently happened, so there hasn't been much time, and the board doesn't see any true rehabilitation yet. And so for applicable federal laws requiring an individual's participation in the occupation, I said he cannot be on a registry list to work on any building that involves kids. So I wrote schools and hospitals as examples. The one thing I wrote is he may continue to be on a list once his sentencing is over, but it doesn't seem like that would necessarily disqualify him from receiving a license from this board.
but it would prohibit him from practicing in Tennessee on any
Those.
facility that
Okay.
had children.
But that would be, we wouldn't qualify his license. That would be up to him to comply. Is that accurate? Yeah, okay. So that's just something he would have to know and be sure he isn't violating. And then I wrote, so if the board does vote to deny his license, they would consider his application 2 years post-conviction, looking for evidence that he had served a sentence, had been successful in therapy, and the therapist believed he was qualified for practice, and that to the board meant demonstration of mental and physical recovery, a low possibility of recidivism, and then I wrote June 2026 as that 2-year mark. So, you'll call the vote?
Yep. 2027. Yeah.
Oh, yeah. June 2027.
So based on those factors, the motion was, just to clarify, was to submit those factors as a reason for denial at this time, and he can reapply 2 years post-conviction. And if that was, is that correct?
That's
All right.
well done.
Yeah, and so we have a motion from Mr. Heathcote, and of course, so we have second from Eddie Jett for roll call vote. Aye or nay will suffice. James Collins.
Here?
Excuse me, I'm sorry. Yes. And then Dr. Ash El Sayed, Eddie Jett,
Yes.
Alton Heathcote,
Yes.
Philip Lim,
Yeah.
and Jason Carter.
Yes.
Okay. All right, so that was unanimous in the affirmative for that denial in support of that motion. And we'll get that filed, and we'll reach out and then communicate that to him accordingly. Anything else?
That's it.
All right, thank you.
I got a, outside of this, I got a question. There's, forgive me if I ask the wrong question here. Does the board still do a retreat on annual basis? The reason why I ask is because a lot of times issue like that, we could use it like a retreat item when we talk about it.
We don't. We have historically, but we're moving pretty efficiently now. We unless the items that are actionable are just handled in committee, or
Okay.
we're pretty flexible too. Instead of waiting on those opportunities, what we've done in the past is either call, the chair will call a meeting or convene a committee if we needed to for those very purposes. So, and we do that every two months. So,
Okay.
yeah, so far it's been sufficient.
Thank you. The only reason I remember a retreat because we make the architects buy our dinner. Thank you.
I appreciate that. Yep. All right. I think we're ready then for the application review then for prior disciplinary action. So, this is just, obviously just to reiterate and, at the last meeting, and this will show up in the comedy app review policy, it was determined that if prior discipline in another jurisdiction is at least 5 years old and the license was reinstated and remains in active status without restrictions in the same jurisdiction as the state of discipline, the application may bypass the application review committee. You remember that? We had that discussion, yeah. And we adopted that in the policy, and the architects are going to get an opportunity to do that today. The only thing with this one is just the age. If this was 5 years old, we would approve it. But since it's not, it doesn't fall succinctly underneath that delegated authority. So that's why it's coming to you today. But for that purposes, I'll just read through it. Date and location was Louisiana. That was March 2025, so very recent. Applicant was found to have aided his firm in offering unlicensed engineering services in the state without the firm having a COA on file, a certificate of authority, if I can get it out. The applicant was registered as a PE in Louisiana at the time. The conclusion or the sentencing of that was he had a $500 fine, rules and laws exam, ethics class in his jurisdiction. Very similar to some of the things that we do, should we have something like that, in our jurisdiction. Mitigating circumstances, applicant maintains his Louisiana license, no other discipline noted on his record.
Has his company been issued a certificate of authorization or certificate of licensure?
I believe so. I don't have that one in front of me. I don't think it may be in here, but.
I would want to know that.
Yeah. Well, that's usually the terms before they close it out. Otherwise it would still be an outstanding.
I would assume that was the case, but can we confirm that?
Let's see. Yeah, it doesn't look like it's within the summary of facts as far as follow-up. Obviously they're going to be somewhat limited in their summary. Typically, the scope is going to be the violation itself, but yeah, he was granted or still maintains his license there. So he would be out of compliance and still in violation. So I suspect that just the preponderance of evidence would suggest that they would have taken care of that there in Ohio. Otherwise, it would remain open.
And to clarify, this individual is applying for comedy licensure?
Correct.
Yeah, so his consent order was signed in March of this year. Has he provided any information saying that he has complied with the terms of this consent order?
No.
Hey, Eddie looked it up on the Louisiana licensing page, and he does have an active certificate.
Yeah, he
for
does.
the company.
Okay.
When was it?
For the company.
He's still licensed.
Yeah, he's still
It says
licensed.
he is still licensed.
No, he is active. At the time that we submit this to you, he was active. Yeah.
So he does have an active license, and his firm is now registered in the state of Louisiana.
It does appear that way.
Yep.
I would suggest he be allowed to proceed with application.
A second.
Okay. Got a motion from Mr. Carter, a second from Mr. Heathcote. All in favor, please say aye.
Can I ask a quick question?
Yeah, of course.
I know this is a kind of pet peeve. I think you educated me. Since the the Louisiana requires them to take the law and rules, is it enforceable for us to tell him to take our law and rules too?
Unfortunately, no, unless we had an active complaint in front of us, then we
Right now,
could.
no.
Yeah,
Okay.
yeah.
Thank you.
Yes, sir. All right. Any further discussion? All right. Okay, yeah. All in favor, please say aye.
Aye.
Any opposed? All right, hearing none, we'll allow him to proceed then with his application. All right. We were stretching you this morning, weren't we? Let me get there as well. All right, that was all we had on the report. And thank you to the staff, legal, everyone. Everyone was pretty flexible. See the information, just kind of grabbing what you needed real time. So that was neat to see, and I appreciate y'all's support. And thank you for helping us out there. So anyway, looks like we got those things moving. Those are always difficult decisions to make, and you were able to separate all the important pieces and move those along. So that leaves us then with new business, Chair, if you had anything to add. And we've got a little bit of time. We've got about 20 minutes then. That's the extent of our time for this meeting.
Yeah, the only thing I had was we have the National NCES Committee meeting coming up in later this month. I know one of the things that we'll be asked to approve there is the minutes of the Southern Zone meeting, and if anybody's had a chance to read those, there's not a lot of meat contained in those minutes. So I don't know if there's anything that we would, anything in there that would need to be corrected. It was all pretty straightforward things. And we've already talked in a previous meeting about some of the items that were discussed in detail, some of the things that are coming up potentially at the annual meeting, such as the policy on AI and some things like that. So I don't know if there's any of those items that anybody wanted to talk about further before we assembled at the meeting and had to vote on those things, or if everybody's okay with it as it is right now.
I would suggest we discuss it after the meeting.
Yeah, that's fine, because unless sometimes, the association business does overlap with board business, but not always. And so if it's strictly association business, then you can have that sidebar and discuss that, much like you would do at conferences, whatever. It's just when it enters into the scope of public health, safety, and welfare, and it necessarily or touches upon our fiduciary responsibility to the public in our positions. At that point, we definitely need to have an on-the-record meeting and do what we're doing here. So that you'd be privileged to do that if you wanted to.
Okay.
Yeah.
Okay.
Any other new business or?
Yeah. Anybody else got any new business?
No, sir.
All right. Well, we can adjourn since it's a continuous meeting.
Got one thing, Casey reminded me, we've got the Tennessee Engineers Conference coming up in
September,
6
right?
weeks or so it'll be before our next meeting. Do we need to
Does she still want you
discuss,
guys to be
approve?
there? Oh, my goodness.
Not only be there, but to stand up and embarrass ourselves in front of the 600 people.
Well, they need a target, you know what I mean, for all that. All right, so, in that regard, we can just, I'll collect that information from you guys at the end of the meeting. We'll just get a head count of who's going to go. Outreaches are fine. Because we treat those like we did board meeting. That's a part of your regular function. It's when we, send you for conferences and stuff that we need to get that authority level. But for outreaches are just a part of what the board does as a part of its daily function, and we reimburse that accordingly. The only time we would have to fill out a travel authorization and then get additional authority is if we're paying a conference fee and we're going outside of state lines, and at that point we need to make it official. But in this regard, you'll be okay. But so afterwards just let me know who can, and then like before, we'll start developing an agenda of topics and then go from there. Is that okay,
Casey, is the board standing up and making presentations part of the agenda for this time?
Yes.
Hello, Casey Anderson with ACEC Tennessee. Yes, we would love for you all to do the PE luncheon like you usually do, just to have maybe just a little panel discussion where you can sort of give the update of what's been happening here, but nothing, no big policy or any of that. But would love to have your participation.
I mean, I think, Glenn, you answered my question there when we go representing some of the things that we take issue with that, it may not be necessary to be at a board position, so we got to be very clear on that. That ties back to the Southern Zone meeting too, because if we have anything that want to take issue with that or we take side or not, the other side, we still had to kind of formally agree to it. But in this case, we're there just to share our outreach. I think it'd be okay, right? That's the way I heard it, yeah.
Yeah, typically, like we did before, we just provided our regular disclaimer, and typically we try to stay on topic of things necessarily within our scope. I mean, obviously you have individual experiences that you can share in it, but at that time, you would have to make that clear that would be your experience, but not necessarily the position of the board. And if we were presenting a position of the board, then we would need to vote on that, because that's coming from the board, so it needs to be sanctioned by the board. But if we're talking about licensure and administrative type issues and things of that nature, like we did before, or industry things that are happening or that we learned or gathered from NCWS that we're sharing, then just a proper disclaimer is sufficient. Thank you, Casey.
We elect you to offer that and prepare and offer that disclaimer at the beginning of this.
Yeah, we did that, if you recall, at our last one at the slides, yeah. And so we'll do that again.
You just pull that same, PowerPoint out, we'll go again.
All right. Anything else?
Only thing that I was approached in one of the meeting recently that they were asking us whether the engineering committee will consider doing some outreach on the workforce development. As you know, in that TVA and the rest, we've been looking a lot in the nuclear side of the business. And one of the feeling was that how are our architects, engineers from out there, are they really up to speed with some of the new skill set? And I thought I'd bring it up, the engineering committee. And I think I consider it as outreach. It's nothing we take side or nothing we take position, but I think the committee and board traditionally has always tried to help the profession. And I think if we get to meet with the dean is one area we need to support them, because there are a lot of words out there about nuclear terminology that I wouldn't even know how to remember them, to tell you. But I think that we're coming up with a lot of new things, and all the more what I'm really thinking that in the exam, where the nuclear engineering exam used to be not many people take the exam, I think you're going to see more and more people come. Of course, Tennessee, we don't really license people by discipline, but I think this is one area we need to be watching and encouraging people to get into.
Yeah,
Thank
and it's
you.
growing too. Tennessee Tech got a whole nother boost, and I think there was some state senators and reps up there that have really been pushing us expanding the nuclear side of the shop. And I think Tennessee, especially with TVA, is going to be a leader. And you're going to probably hear more about that, and it'll trickle into NCWS. And with our energy issues, ongoing, I think that, nuclear is definitely an opportunity.
Which is interesting, because didn't NCWS just elect
Yes.
to
I think that's one of the topics for vote at the meeting in a couple of weeks.
Yeah, that's correct.
to do away with the nuclear
Exactly.
exam?
Yeah.
That's what was in the back of my mind when I made that statement, because I think they may have to reconsider that at some point.
Yeah, so at this point, I think the reconsideration of that and restyling of that is going to go through the same process, whether the exam is postponed or suspended or whatever. It would have to go through the same reevaluation or recreation of the exam. And that was one of the things that was discussed with the committees that were involved in that decision, was everybody recognized how important that exam is now in particular. And it was really concerning to everybody that they weren't able to get more participants to take the exam. And it was not like holding steady even, it's just been like steadily declining now for several years. So that was the discussion. And I would tell you, nobody on the committee wanted to get rid of the exam because of the importance of it, but because of the declining numbers got to the point where the exam was no longer viable, the results were not viable anymore, so they had no choice.
Well, you know, that kind of brings up another point. That, you know, industries or engineers that are employees of industries have always enjoyed the industrial exemption. And at what point does that become a threat to the public health, safety, and welfare?
I think, you know, Tip, in the past, you would have the federal government leading leading the charge when it comes to the nuclear side of things, obviously. But I think Tennessee's going to be a leader because Tennessee recently invested a ton of money. So I think in that regard, because they see the interest just for our state. I mean, for growth and development, for business to come here, we've got to solve the energy problem. You know, unless we're sitting on a bunch of oil, you know, how are we going to do that? And so I think they're looking to expand. If the federal government won't lead in that regard, then Tennessee's not going to wait around for them, is what I'm saying. And so that pipeline that didn't exist before may just be a trickle from Tennessee initially at first, but I think it's going to build. And then maybe other states catch on because they see the benefit of it. We'll see. I mean, we don't know. That's all speculation at this point. It's in its infancy, but I think they'll be talking about that part of the exam again.
Yeah, I think so too. And one of the issues that is kind of a problem with the nuclear side is the federal regulatory boards. If anything, they discourage the people from being licensed PEs. They're not required. None of their employees are required to be PEs, and they're not encouraging other people to be PEs that are working in these facilities. So that's a big issue right there. But hopefully, like Glenn said, Tennessee can kind of maybe lead the charge on this and push it a little bit. And it would be really amazing if we could get that.
I think if
back.
we had support and leadership from upper echelon and TVA, that would go a long way.
Yeah.
I think if you look at just the project, the Clinch River project right now, there are a lot of architects, engineers, and you'd be pleased that they need civil engineers because you're thinking about those small nuclear modular reactor, they need water cooling. So you need people who understand water engineering. And the reason why I brought this up is because there's a lot of buzzword. I just came back from a 2 days meeting at UT, and they talk about nuclear. And I said, thinking and sitting there, I said, what role do we need to play? And I recall 25 or 30 years ago when the Energy Solution Company came about, people were getting their CEM, Certified Energy Manager. Without a degree, they were getting it, and they were practicing that. And we have cases where we bring these people, organization, into the board and say, you shall be registered, have a PE on record. So not to make things difficult, but I think that the reactors part of it is probably going to be designed some top scientists. But in terms of the A&E work, like mechanical engineer, matter of fact, they will tell you that they are looking for people who can have mechanical background, civil, and also the plumbing and the welder. Those are the type of people they're looking for. And I think we have a chance to brace the trail, especially when our governor has a board on the Nuclear Commission. So I think we need to pay attention to it and let the governor know that we are paying attention to this. And this, because I know that 20, 30 years ago, nobody wants to take nuclear engineering PE portion of it. So thank you for allowing me to share a few minutes. Thank you.
Those are great points. You guys are thinking ahead, as always. I mean, that was fun to see when we were looking at NCWS's AI statement, and you guys could have crafted it for them, and you already did that. You should have saved them some trouble, right? You know, they should have just talked to y'all first, and then they, cut that short about 2 months. All right. Well, anyway, anything else? No? Okay. All right. Thank you, gentlemen. In that case, we'll just take a quick little recess, and we'll be back here at 10. Thank you. All right, our distinguished chair, if you want to call this one to order, we'll do a roll call.
We'll call the August meeting of the Board of Architectural and Engineering Examiners to order.
All right, thank you, sir. All right, for roll call, Jason Carter.
Present.
Melanie Doss.
Present.
Philip Lim.
Yeah.
Blair Parker.
Here.
Rick Thompson.
Here.
Brian Tibbs.
Here.
Frank Wagster.
Here.
Dr. Ash El Sayed.
Here.
Jeff Nally. Alton Heathcote.
I am right here.
Eddie Jett. And James Collins.
Here.
And, yeah, I already told, I broke the news to the engineers this morning, and even against, our judgment and our efforts, Alton was reappointed. So I'm sorry to break that to the rest of you. But let it be known that we did all that we could. All right, all right, welcome back, Alton. Good to have you still with us. So we're looking forward to the next few years.
Above ground, vertical, and ready to serve, my friend.
That's right. All right. So just a quick note to anyone that may be watching or in the room. We do have a notice of public comment period located at the end of the agenda. I always just make that note so people can be prepared to provide those comments should they want to do that. That will happen right before the adjournment and right after new business at the end of the agenda. The meeting notice. Notice of the August 7th, 2025 meeting of the Board of Architectural and Engineering Examiners has been noticed on the website since December 18, 2024. This month's agenda was posted on July 31st, 2025. As for announcements, two things. All right, we have a new admin manager. Yeah, you knew about Heidi. She was going to be with her husband as he's moving up the ranks at Fort Campbell, and he's sort of a kind of a big muckety muck over there, and looks like he's going to have probably a few more years in the military, and so that's going to require a lot of her. We kind of knew it was temporary with Heidi, and so but we were fortunate enough to keep Melanie with us. She's worked with regulatory boards for a couple years, and she's worked on the admin team there across a lot of programs. So she was able to hit the ground running, and we're excited about having her with us. So hopefully you'll get a chance to get to know her more, and I look forward to the years ahead with her at the helm as well. So thank you, Melanie. I appreciate that, and glad to have you here with us. Also, there was Nathan Ridley. If some of you don't already know, he is no longer representing ASLA, but has since joined another law firm and is now representing the Associated Building and Contractors Organization. So I suppose that you'll have to poke your head in the contractors board meeting if you want to see Nathan. So if you want to sort of get him rattled a little bit or come around legislative season and contractors are up, maybe you just need to poke your head in and kind of make sure he's doing his job and he's still on point.
Let's hope whoever his replacement is knows how to speak into a microphone and turn it on.
Well, that's you just set me up. That's Charlie Snyder. I don't know if he's already here. Oh, there's his replacement right there. So you'll be getting your.
I'll just tell you right now, Nathan was notorious for standing over the microphone and talking into it without it on. And Nathan talks in a really low voice anyway, so it was somewhat hard to hear. So don't make the same mistake.
But I'll also add that he was great to give us a civics lesson every time he stood at that podium. So it was always helpful.
Yeah, I didn't mention that to Mr. Snyder when him and I had our introductory meeting, but we're going to be needing that civics lesson going forward. Yeah, but I have a feeling after meeting him, he's up to the task. I feel very confident that we're going to be in good hands in that regard. All right. Looks like we are ready for. I guess we need to adopt the agenda, and then we do have a rulemaking hearing day, so we're just going to get a couple little stuff out of the way, and then we'll jump in the rulemaking hearing. But right now, we need to adopt the agenda.
Is there a motion to?
So make a motion to
Okay.
accept the agenda.
We got a motion from Blair Parker. Do we have a second from Brian Tibbs? Is that correct? Yeah, he said yeah. All in favor, please say aye.
Aye.
Any opposed? All right, hearing none, the agenda is passed. Then we just need to take a look at the June meeting minutes. Do we have a motion to accept the June meeting minutes?
So move.
Got a motion from Ms. Dawes. Do we have a second? We got a second from Mr. Tibbs. All in favor, please say aye.
Aye.
Any opposed? All right, hearing none then, the June meeting minutes are passed. We'll get that up on the website here shortly. Professional society reports, then our rulemaking hearing after that. So professional society reports, Ms. Anderson.
Good morning. I'm Casey Anderson. I'm the Executive Director of ACEC Tennessee, and I'm also, for the purposes of this board, I also represent the Tennessee Society of Tennessee Society of Professional Engineers. Just a couple of quick updates. We talked at the Engineering Committee. The Tennessee Engineers Conference is September 15th and 16th at the Franklin Marriott. It is a joint conference, a joint effort between ACEC, the Tennessee Structural Engineers Association, the Tennessee Society of Professional Engineers, and this year, also ASHE, the Highway Engineers, both for Middle Tennessee and the Tennessee Valley chapter. So super excited about that. We're looking at probably about 700 people at that meeting. It's going to be a really great one. We've got 7 tracks, a civil track, a separate environmental track this year, structures, electrical, mechanical, industrial, geotech, transportation, and engineering management. And then we'll have some several general sessions as well, which for part of that will include having a little panel discussion with the AE board, fireside chat, if you will. So that'll be exciting. I appreciate all of that. EEA, our Engineering Excellence Awards, are going to be November 10th. Those are going to be at the Four Seasons this year. The projects are due, part 1 of those projects, which is essentially an intent to apply, are due tomorrow. I'm really excited about some of what we're seeing this year. There's really a lot on the street that's going to be fun to celebrate for our industry. At those awards, we'll also give a Young Professional of the Year award as well as a Community Service award. So looking forward to that. Those folks who win here are then eligible to go to the national competition of those awards. We are going to run our 2nd annual vertical conference this year. It is focused mostly on MEP and structural. It will also this year have a land development component to it. It's going to be November 10th during the day at the Four Seasons. So looking forward to that. You'll see a lot of private market conversation rolling through there as well. It'll be a little bit on the public side and a nice focus on the private side and private markets. And then the last thing I'll mention is the outstanding work that our Workforce Development Committee is doing right now. We are fortunate in Tennessee to have Rodney Chester, who's the CEO of Gresham Smith, is the chair of the National Workforce Committee for ACEC. Susan Osterberg, who's the CEO of Smith Seckman Reed, is one of the 2 co-chairs of that national committee. We are going to be the tester for everything they do up there. They have launched a engineering workforce consortium that includes at this point about 18 different groups from all over the place. Everybody who's involved in STEM of any kind is kind of a part of that group. And what we're trying to do is figure out a way where we're all working together to move the needle a little bit, or a lot of bit, if I'm being honest. It's a lot coming down the pike. We're focused on 3 different areas. One is the sort of elementary and high school level. How do we get people to decide they want to be engineers? Then we've got the college tracks of trying to make sure that they want to commit to engineering and stick with it once they're in there. And then we've got, on the backside, we've got the retention side of making sure we keep people here. So we're doing a lot of work on externships and internships and going to have some really exciting game days. And when we get to the point that we're ready to roll that out, I think there's a great component for you all in that. We're thinking that in Arizona, they took 1,400 kids at a time to a stadium and had set up of every different kind of engineer around it and said, this is what I do, this part, this is how this works. And we've got so many new athletic facilities across our state. We think there's some really good opportunities to do that and really see thousands and thousands of kids a year who maybe aren't involved. And to me, you all might have a really interesting role in that. So we'll come back to you with more information. But there's a lot coming from workforce development, and as we start to develop actual materials for folks to use, I'll make sure that all of you have that as well. But unless you have any questions, there's a lot coming down the pike, and more to come next time. I don't know, is someone reporting for Ashley?
No, she hasn't reached out yet, so if you had something, yeah.
So Ashley, the AIA, their design conference is today, right? And so she won't be here, but I'm sure that these 2 can give a good report on what's happening over there.
Yeah.
I just didn't
Brian
want her to get
Tibbs has
left
his
out.
finger on the pulse.
Well, I thought Ashley had mentioned someone may be coming to, I don't know if the representative came or not from it, but
Yeah, if, do we have somebody here from Ms. Cates? No, okay.
Did you have a question, Philip?
Casey, thanks for the report. I'm interested in just kind of outright ask you how we can support you in the workforce development category. And I think we are thinking the same thing, so I think applaud you for that.
Thanks. I think honestly, one of the things you will be able to support us, and I think what we're really trying to put together at this point is a foundational structure that's going to get us there where there's a way for other people to dive in, almost like the great work of Hands On Nashville does, where people can sort of go online and see what's available and go in and do kind of micro things. But then we also have some really big heavier lift ticket items that are coming too. I'm not sure what that role is going to look like quite yet for you all, but I do think there is one, and I think that you're an important piece of it, because part of what we've got to move people toward, particularly the college age students, in my opinion anyway, is making sure that they understand the licensure piece. And as much as you all have been committed to making sure that those students have access and the means to take the FE right away, you know, we all know that they're more likely to take the PE down the road if they've already knocked out the FE and that kind of stuff. And so there's some pieces of that it's sort of an elephant that you're just trying to bite off one bite at a time. And we've got a lot of people taking different pieces of it right now and are trying to kind of masterfully craft a bigger piece together that makes sense for everyone, where everyone can dive in. So we'll get there. You'll be at the table, I promise you that.
Thank you.
Appreciate you. Thank you very much.
Thank you, Casey. All right. Let me get to the next one. Miss Suzanne Heron is not here today, but Jackson Sowers is. And he is coming from ASCE, American Society of Civil Engineers, and I believe he has an announcement for us.
Looks like it's already on. Morning, everyone. Just a short update from ASCE. So next year, Friday, February 13th, ASCE is hosting their first conference down at the Smyrna Town Center, and would like to invite all available engineering board members to attend. Sorry, I don't know too many more details. There was a planning meeting yesterday that I could not attend, so more details to follow.
And just to pile on there, just like the Tennessee Engineers Conference, as we get closer to time, I'll get a head count from you guys as well, as to who would be available. It is to Mr. Sowers' point, it's in the Smyrna Town Center there, Sam Ridley Parkway. It's a nice facility. It's relatively close, central here. But to his point, that's not coming till February 13th. So as we get closer, we'll probably have a little, we can start forming that agenda then as well. But mark your calendars for that, and that's another outreach opportunity that we want to be aware of and participate in if we can. Thank you, Ms. Sowers. All right. The next one then, of course, I'll just pause for a second for Miss Ashley Cates to see if anyone's online. Alex, do we have anyone online for Miss Ashley Cates? No. I didn't expect her to step out of what's going on there to give us a report, but just in case for some reason she was there, I want to give her opportunity. All right, Mr. Snyder for ASLA.
Thank you. I am Charles Snyder. Charlie's fine, and I am going to be following Nathan Ridley, and I have a loud voice anyway, so if the microphone wasn't on, you'd be able to hear me. But Glenn, thank you for meeting with me to sort of discuss the board, the scope of landscape architects. So I will be representing the Tennessee chapter of ASLA, and just to sort of introduce myself a little bit and not really give you the big civics lesson this time. I've been lobbying or engaged, was at one point in the Haslam administration, this department, but over 25 years around this area. Previous to joining Bradley in January, I represent a lot of construction and development clients, so that side of things. And I've always worked with Casey over the years on a variety of things just to make sure, and the architects as well, really local communities, land use, planning, design, construction, all the way through. That ecosystem is very important. And I guess one of the things sort of in this area that I was most proud of is when COVID happened and everything sort of disrupted, right, is everybody in the design and construction space worked together to provide information to the governor's office for the executive order so that business could continue in a responsible way, right? There was a lot of things that had to change. We had to sort of logistically move some things around. And depending upon the community we were in, working with the local officials to approve things, continue in a timely manner was a big part of that. So wanted to give you that little background for myself, and I am a lobbyist for a variety of clients at Bradley, care about the continued healthy growth of Tennessee, East, Middle, and West, and have a lot of friendships sort of in this space all across the state outside of professional work. So I'll take a breath there and see if you have any questions for me. But
I was just interested how you keep that upright 1960s freezer still working after all these years. I thought that was an interesting fact. I was like, it probably takes care of itself, I think at this point. I need to be in the market for one of those. But I enjoyed talking to Mr. Snyder, and I think he's gonna fit nicely with this board, and look forward to the years ahead.
And since we were talking about conferences, Landscape Architects had their conference in April earlier this year. They are currently without an executive director, so there's not a firm date for next year, but we will keep you informed on all of those matters.
Thank you, sir.
Thanks.
Miss Hannah Finch, or Claudia Lofton as well.
I'm actually going to start by asking Susan to come up here and kick us off. Obviously, many of you know her. Everyone should know her by now. But previously on the board, but just wanted to get an update because obviously she stands for NCARB and a number of things. But yeah, I'll let you take it away, and then we'll dive into just some logistics.
Okay. Thank you very much, Hannah. It's good to be back and see everyone on the board again. Glenn, now we can meet, except by the phone. So I am Susan Ballard-Gribble. I attained fellow status 2 years ago with the American Society of Interior Designers. I am on the National I-Corps Committee for 3 years now, and we are coming to a close. So you all will be getting a report, hopefully. The state of Tennessee is in good shape already because this board's done their job. But some people need a little more guidance, so we're making things so that they're in everybody's lane a little bit better. I was on the board from 2012 to 2020. During my second term, the AG's office asked for definitions from all the professions, which were not in place at the time. In 2019, CIDQ initiated definitions and they were approved at our conference. So I came back and presented them to the board. And I'm so thrilled, 5.5 years later, we're having a rulemaking hearing today. So I'm here to support that and to let you all know that as a profession, we want things to be health, safety, and welfare for the state of Tennessee and to work with all the professions. And so I do have some sets of drawings to show you what interior designers are doing on the commercial level now. And I don't know if any of the other ladies brought theirs, but I'll have them in the back. But one of the things I wanted to tell you all is in Tennessee, I have done 75 hotels in the last 10 years. I cannot stamp those drawings. But the same hotel in Florida, I could stamp. So I want y'all to think about that in the long term. We're not changing anything now, okay? But it's something for y'all to consider. And I want y'all to see what interior designers are doing now, because I think it's important. So, Hannah, you can take over.
Thank you, Susan. All right, I'll start off with ASID. So we really had a successful few events, but the main thing being our annual Industry Partner Appreciation Night. It's one of the first times we've actually had it at an industry-specific location. So that was at Walk Your Plans, Nashville. If you have not had a chance to experience that, it's an awesome organization that It's just amazing from someone who started, hand drafting plans as a student, and now everything has gone virtual. It's just the coolest thing. But it allows clients to actually walk through live in real scale through their plans with your designer or with any other design professional. So that was really cool. We actually played some fun games like Clue and Bingo on a projected board. Amanda's great. She owns the franchise here in Nashville, and they're just expanding out throughout the U.S. So very, very cool. Next monthly meeting in CEU, that's going to be at Myers Flooring on August 12th around lunchtime. Biggest update is our nominations are complete for the new board, and voting is live as of yesterday. So they will begin their term October 1st. That's when everyone will roll in and the old board will roll off. I'll become past president. In line with the new board, our strategic planning meeting is going to be held August 17th through 20th. So we're actually doing that in conjunction with our national conference Gather. That is held in Atlanta this year, so a little bit closer to home, so we're able to send more of our board members. It allows us to all just gather and have a little bit of a retreat. And that's also when we'll update our budget for the coming year. We will take into account our national membership allocation changes that have happened last year, and local annual sponsorship. So all of that will be updated, and of course, we'll come out with our new plan for the year. And just to note, there is an updated leadership training this year for our national conference. So they're actually diving more into seeing that is a need to just get the future leaders of all of our professional societies up to speed. It'll be fun to kind of interact with other groups across the U.S. Our annual state conference is going to take place on Thursday, September 18th at Riverside Revival. That's going to be our awards gala year. And then on that Friday, the next day, our portfolio review is going to take place at MTSU. So we kind of have been asking students, like, what is the need? They're really wanting to say, hey, can you help prepare us to actually, join the workforce? So we're going to be doing that. We also are having a panel discussion that we were able to get approved as an IDCEC CEU. So that should be great for some designers. We're going to focus on health, safety, welfare. So it should be overall a great experience. Registrations for those design awards are still live. We did extend that just to make sure that all categories were filled and represented correctly. There's still some sponsorship opportunities available. The theme this year is Legacy in Motion. It's because we're celebrating ASID's 50th year. So that's a huge achievement for us. It's our golden year, so should be a great time for us. Lastly, as far as upcoming events, ASID is also partnering with NKBA, the Kitchen and Bath Association, to market it's a new nonprofit organization actually out of Texas that's kind of expanding called Designers for Dogs. This is basically saying, we have a passion for our lovely pets and how to incorporate them in our homes and other designs and things like that. So that's a nonprofit that's actually coming in. This is the second event that they've done, period. And that's going to be held at Christopher Todd's new showroom and grand opening on September 25th at 6 to 9 p.m. He's located over in Belle Meade. So we're just opening that up to all design professionals, helping plan it, market it. Nashville Humane Association will be on site with adoptable puppies. So that's a huge, that's a draw right there in itself. And of course, registration will be live on all of our profiles, socials, all that. I do encourage you to follow us at ASIDTN. Same thing with IIDA. That is, we all have similar handles just to see what upcoming events are happening to be involved. I'll leave it to Claudia for IDA.
Hi, everyone. All right, so our board recently just switched over on July 1st, so I am officially the past president for the IIDA Tennessee chapter. And I have Allie Bierman and Brandy Kelly here, our new president and president-elect, so y'all will be seeing some more of them in the upcoming years, which is great. We have our annual planning session for our new board next weekend on Saturday, August 16th. So we will have all of our board members from across the state. We now have 11 different architecture and interior design firms represented on our board across all 3 city centers, which is super exciting for us, and we hope to keep expanding and adding members from across the whole state, not just Nashville focused. IIDA Tennessee chapter was awarded the 2025 IIDA chapter award from HQ this year for our Rise and Refine event, which happened in January of this year. It's our first annual, and we will be doing this moving forward, but it's a professional development summit day. This came out of results from surveys that we did to our membership of how we could better serve them. It felt like a lot of our professional members were actually feeling like we focus a lot on emerging professional student members, things like that, but where is the middle management support? How are we helping prepare our designers to move from production roles into management roles and leadership roles within their firm? So it was a well-attended event. We really loved it. So we're going to continue doing that, and the focus will shift each year. But we were honored to have that award given to us by IIDA nationally. In addition, we also, the University of Tennessee at Knoxville received the 2025 IIDA Campus of the Year Award. So they only give one of those away every year. All campuses across the nation submit for this, and so we were so excited to receive that award on behalf of that chapter, the student chapter. All right, let's see what else we've got. We have registration and sponsorship opportunities that are going to be opening up in late August. We will be announcing the new package at our biannual Threads event, which is happening at Geodis Park on Thursday, September 25th. We're also hosting a first ever sponsorship roundtable the night before our board retreat. So next Friday, we're hoping that this will give us a good opportunity to chat with all of our gracious sponsors and learn about how we can be better partners with them moving forward. Couple of upcoming events that we have going on. Our Memphis City Center is hosting their Zero Landfill Recycled Material Donation Drive on August 26th. August 9th, our Nashville City Center is hosting a committee planning day to begin organizing all of our 2026 events. And then August 16th is our board retreat. So we'll plan on having a full 2026 calendar of events coming out towards the end of this year so that everyone can work on planning what they're going to attend for the next year. And then we have our joint Better Together events. We're still working on planning some of those in this upcoming year. So we're kicking off another planning meeting tomorrow at 3:00. We'll recap on our past events, talk about an upcoming networking event that we'd like to do together, and then continue to just speak about advocacy on behalf of interior designers and getting more and more designers involved in our organizations.
And speaking of advocacy, we just wanted to publicly announce the new NCIDQ certificate holders for this year, or for this season. So that was live recently. So, and this is in conjunction, this is members of both ASID, IIDA, and then hopefully future members of either. First we got Isabella Claiborne, Lydia Fanning, Natasha Hagan, Allie Harrison, Mallory Humphreys, Elaine Hunter, Christina Larson, Megan Lloyd, Heisey Lopez, Lauren Lucchesi, Sydney Moore, Tiffany Murphy, Kara Purcell, Kate Reeves, Rachel Smith, Nicole Steele, Juliana Stevens, Kali Thompson, Isabel Tizer, Cara Ventura, and finally Joseph Wessels. So a good group this season. So again, this is twice a year. So this is a great list to be able to announce. Congratulations to all of those, and we'll be following up with next steps to register. So, any questions for either ASD or IDA's professional society report?
Yeah, it's hard for me to keep up with you guys. You guys got a lot going on. I mean, I don't know how y'all manage all that, but thank you.
A lot of committee members.
Yeah.
Yeah.
Thank you very much for the reports. Thank you, Susan. for your report. Also, we'll be looking forward to all of those new CIDQ certificate holders to becoming registered interior designers. So, great. Thank you so much.
Thank you.
All right. Thank you, Professional Society members, for your reports and reps. And looks like then we are ready for our rulemaking hearing. So this will be legal and our court reporter driving this one. And you should have a printout of those edits that I sent to you late. I mentioned there's a couple changes that we need to make to that. So if, this will be the one we'll be referring to as we go through it. And then Chris, thank you for printing that out this morning too. I appreciate that.
All right, good morning again. So this rulemaking hearing is called to order. So everything's going to be recorded by our court reporter here. But that said, please definitely remember to press your microphones. I don't think this board has had a rulemaking hearing in a while. So just as a reminder, there is a lot of information that I'm going to read into the record. But then there will be time for us to sort of discuss public comments and possible edits. But please, if you have any questions, let me know. But just wanted to give you a heads up that I will be reading a lot of information into the record. So here we go. My name is Laura Martin. I serve as Chief Counsel in the Department of Commerce and Insurance, Division of Regulatory Boards. And then the other agency representative here is Glenn Kopchak. It is Thursday, August 7th, 2025. This rulemaking hearing is taking place pursuant to Tennessee Code Annotated Section 4-5-204 in Conference Room 1A in the Davy Crockett Tower, 500 James Robertson Parkway, Nashville, Tennessee, and is available by electronic means via Microsoft Teams, which can be located on the Commission's website, the board's website. I'm not going to read the webpage. On this page, the link for access to this rulemaking hearing will be found in the chart located next to the date, which again is August 7th in the location column labeled Connect. The purpose of this rulemaking hearing is to solicit comments on rules of the Tennessee Department of Commerce and Insurance Regulatory Boards Division, Board of Architects and Engineering Examiners rules that they have made public. These rules address the retrospective review that was directed by the legislature, and then the rest of, and most of those are updates and cleanups, and with intention to clarify current processes. These rules also contain definitions of the professions, which the board has spent many years debating, researching, and writing. The purpose of these definitions is to offer more clarity to licensees and non-licensees about what the board considers to be the practice of the professions of the board. A rule is defined as an agency statement of general applicability that implements or prescribes law or policy or describes the procedures or practices requirements of the agency. Rulemaking hearing rules are filed with the Office of the Secretary of State. Notice is given to the public for comment, and a rulemaking hearing is held. Upon conclusion of the hearing and adoption of the approved rules or the proposed rules, the rules are forwarded to the Attorney General's office for review of legality. If approved, they are filed with the Secretary of State, who is responsible for publication, and the Government Operations Committee of the General Assembly will review. The rules must stay with the Secretary of State's office for 90 days, at the end of which time the rules are effective. Those members of the public wishing to speak and appearing in person should place their name on the sign-in sheet. Is it in the back? At the back of the room. The members of the public wishing to speak appearing via Microsoft Teams should please put their name in the chat box. Oral comments will only be accepted by those who have written their name on the sign-in sheet or typed their name in the chat box. Is there anyone here who desires to give oral comments but has not yet written their name on the sign-in sheet or in the chat box? Okay. Seeing that there are none, for those attending this hearing in person, did you put the copies back there? Do we have copies? Okay. For those attending in person, if you would like copies, please contact me and we'll make sure that we get a copy to you and have those available. For those of you attending via Microsoft Teams, there's a link on the website with the red line copies of the rule amendments. The notice of rulemaking hearing included the entire text of the proposed rules and was published on the Tennessee Administrator-Register website on May 27, 2025. Glenn, was there any additional notice given to individuals?
Just a rulemaking notice per procedure in compliance with the law.
Thank you. As the agency hears public comments on the rules, as the moderator, I will reserve the right to limit such comments if they become repetitive. So please limit comments accordingly. So I will read the substance of the rules into the record now. This is a very long rulemaking project, as all of you are aware, so I'm going to read each rule code, and then I've summarized for each rule citation what that rule does. But of course, you're welcome to follow along with the copies, because I got a couple of edits after they were uploaded on the iPads. The most current one that I'm working off of is printed in front of you, and when I'm finished, I can talk about what those edits were, but none of them are particularly substantive. Okay. So Rule 0120-01-.04, Applications General, is amended by deleting the language related to the expiration dates of applications and comedy applications. Rule 0120-01-.08, Applications, Landscape Architect, is amended by updating the authority section. Rule 0120-01-.10, Education and Experience Requirements, Engineer, Paragraph 1, is amended to allow a pathway to licensure for all baccalaureate degrees with the addition of a postgraduate degree with engineering curriculum. Rule 0120-01-.10, Education and Experience Requirements, Engineer, is amended to allow a pathway to licensure for alternative degree types with the addition of a postgraduate degree with engineering curriculum. Rule 0120-01-.24, Duplicate Certificates of Registration, is amended by adding interior designer. Rule 0120-01-.25, Renewal of Registration, is amended by adding interior designers. Rule 0120-01-.25, Renewal of Registration. So that is multiple paragraphs. So in point 25, all of them, it's multiple paragraphs. They're all amended by adding interior designer. I'll skip down to Rule 0120-01-.25, Renewal of Registration. Paragraph 4 is amended to delete the language or fraction of a month so that late fees are determined monthly and not depending on where in the month they're renewed. Rule 0120-01-.25, Renewal of Registration, is amended by deleting the language over age 62 so that retirement is not restricted specifically by age. Rule 0120-01-.25, Renewal of Registration, is again amended by adding interior designers. Rule 0120-01-.25, Renewal of Registration, is amended by removing references to the professional privilege tax and adding interior designers. Rule 0120-02-.09, Civil Penalties, is amended by deleting the cost assessment range for each penalty and instead stating that all penalties range from $500 to $1,000. Rule 0120-04-.01, Definitions, is amended by adding new language to define the term practice of interior design. Rule 0120-04-.08, Renewal of Registration, is amended by deleting language fraction of a month so that late fees are calculated monthly. Rule 0120-05-.04, Basic Requirements, is amended so that for all registration types, PDHs may not be carried to future calendar years. Rule 0120-05-.06, Types of Acceptable Professional Development and Continuing Education, is amended so that evidence of pre-planning is not required to be accepted for credit. Rule 0120-06-.01, Definitions, is amended by removing the definition of principal. And Rule 0120-06-.04, Responsible Charge Requirements, is amended by allowing registrants to be responsible charge of firms where they work full-time, along with meeting other qualifications, regardless of where they live or hold a license in the U.S. Making sure I got all of it. Oh, sorry. It Rule 0120-01-.01 definitions is amended by creating new paragraphs 5, 6, and 7 that define the terms practice of engineering and practice of architecture. That is slightly out of order, but I recognize I missed that.
Laura, I do have a question about
Sure.
one part of that. If you look at under section I-12,
I-12.
What page are you on, Alton?
page 3, sorry.
Sure.
It says a service sign. Is that supposed to say design?
Are you looking at the new copy?
I'm not sure which one I'm looking at, but this is the practice of engineering is hereby explicitly defined to include the following.
Okay.
On mine, it's section I, but there may be a newer one.
Oh, yes, got it. A service, no, that should be a service design.
Yeah,
It's
not
probably just,
sign.
yeah,
Okay.
thank you.
Thank you. Glenn, have we received any public comments by email prior to this hearing?
We have not.
Okay, I also have not received any public comments by email prior to this hearing. Have you received any other type of written comments about this hearing?
Yeah. We did receive some comments from Ms. Ballard, or basically questions.
Okay, so we can discuss those now. So so the rules that were posted on the Secretary of State's website, prior to those being posted, I got comments from Melanie or Susan, or sort of both, about interior designers, and we had added interior designers sort of everywhere in the rules. And in doing that, it sort of inadvertently created the requirement for interior designers to have a firm disclosure, like a firm permit. So I have removed interior designers from that specific section, so that they are not required. They have never been required to have a firm permit, and the purpose of these rules did not intend to do that. We were just adding them anywhere that they had been left out. So that has been removed. And I can find that in a minute. I'm sorry. I had it up just a second ago. And then in addition to that, I received comments, or Glenn received comments from James Collins. He corrected me on a few places where my authority was slightly mismatched. And then also, he brought up the comment that adding interior designers in certain places seemed duplicative. I did not make those changes in the rules.
Yeah, at the time, we were just adding them just basically as a courtesy to the profession, just adding them everywhere there was design professionals, and that's where we kind of inadvertently ended up with a firm requirement, which is why we took that out. Well, obviously, that wasn't the intent of the rules. But if we're going to have to remove that anyway, where it's absolutely duplicative, where they have their own chapter, obviously, this would probably be the time to have that discussion about removing that elsewhere, where it's duplicative. Obviously, if it's listed in their own chapter, does it necessarily need to be where everywhere else is, where it's listed everywhere else? Perhaps not. And then, if we weren't making the change already regarding the disclosure, then we wouldn't even bring it up necessarily, because it's not like it would necessarily. It's not giving any more authority or reducing any authority. It's really a matter of format and edit and being concise. But since we're going to be making a change, this was the opportunity to discuss that.
So what we're saying, I agree with this document as far as the adding of interior designer, where you have just indicated.
So sorry, I just found it, and just for the record, the place where I removed it was 0120-06-.01, and that's where it would have inadvertently created the firm license the firm license requirement. And in the document in front of you, that has been removed. The one that was posted on the Secretary of State's website did inadvertently create that license. But that is an edit that the board will approve today, if they're inclined, which I think they will be. And then I left all other references to interior designers in the rules as was discussed by the board. But this was a comment from James that was brought up that he thought it was duplicative in a couple of places. And I said that that was sort of a board discussion since that's up to the board to decide how they want to move forward with that.
James, do you want to identify specifically where those duplicated efforts
Sure.
are located?
Yeah, so these are in Rule 0120-01-.24. This is on page 6. The duplicate certificates of registration, that same language is included in the interior designers rule, the 0120-04. The exact same language is included there, about interior designers only. Also, in the next section down, the renewal of registration, again, that exact same language is included in the interior designers rule. And then the next section down, the renewal of registration, paragraph 2, that, again, that same language is included in the interior designers rule. And then finally, in the next one down, which is now on top of page 7, the renewal of registration, paragraph 3, where it gives the dollar amounts, that is already included in the interior designers rule as well. So I don't think it hurts anything for it to be here, but it is duplicate information with what's in the interior designer rule.
I think since the other professionals are listed, and interior designers complete that list and are included with that list, then I am not sure it's duplicating information, even though it is stated in the definition or in other areas. I think it's important to include interior designers in the list along with engineer, architect, landscape architect.
Yeah, so, like I said, I don't disagree with that. It's just language is exactly the same in the other section as it is here. And the other section talks about interior designers and has all the rules and regulations for interior designers. And the language is exactly the same as is included in those four paragraphs. And so I just pointed that out since it is duplication of language, that we might want to remove it here and leave it, but I'm okay with it either way.
Is it duplicated for engineers, architects, and landscape architects?
No, that's their, there we go. This is basically, the board has individual chapters, as you know, and one of those chapters was interior design when it got added to the board. And so that language for the sections he identified was placed in the interior design chapter. And so it is duplicative, but it doesn't necessarily, it won't necessarily, hurt anything if it's left there, but at the same time, too, the only reason we're even discussing it is because we are removing it from the disclosure requirement. And so that was an opportunity that if we were going to do something with it where it is duplicative, then that would be the opportunity to do that. That would be that's sort of the last chance to do that before it goes out the door. So we just want to make sure that we acknowledge that, touch on that, or if we take it to GovOps and someone else asks us about it, we can say, okay, yeah, we had that discussion. We understand it's duplicative, but the board didn't at that time. They either made a decision to do something with it, or if it's left in the package, that they opted not to, but they had the opportunity. So thank you, James, for identifying where that's at. And, I don't, at this point, the staff is inclined, as always, to follow the lead of the board. So unless there's a motion, then they would just remain as it is. The only thing that is changed, that we need to change, is the firm requirement, because that is something new that was unintended.
Correct.
All right. So thank you, James, for doing your work too, and that yeoman's work too of getting into the the authority issues, that's,
Yeah.
you know, that's not something that, for the faint of heart, so I appreciate you doing that. And then, you know, comparing that elsewhere as well. And that helps us too, because when we go with the GovOps, we need to be equipped with every arrow in our quiver that you know, we don't need to leave any stone unturned, because if we're having discussion now, if we see it, other folks are going to see it too, so we need to be talking about it, you know, so that way I'm going up there, and now I have something here from the comments and from the discussion with the board, so should it come up, then we can let them know what the board's decision was on that, if any. It's all right. Unless there's a motion, I think we can move on from that point. Yes, sir.
Yeah, just one other comment. I noticed that in several of the places in the authorities that the portions of the law that refer to the privilege tax, occupational tax have been removed, but there's still some in here that have those listed. Should all of those be removed, or were those left in on purpose?
I believe they removed all the authority relating to professional privilege tax, but if you're seeing other, like, references still in there, then I can remove that.
Okay.
Remind me which one that is? Is
So
that
that's
67?
67-4-1701 and 1702. Page 7, there's 3 places there where it's still listed, and there's 2 places on page 8 where it's still listed.
Mr. Collins used to be a law clerk. I don't know if y'all knew that.
I used to read a lot of contracts. So.
For the record, I did greatly appreciate Mr. Collins going through this with a fine-tooth comb. This has been a long time. A lot has changed in the law since this rulemaking project started, so I try to catch all of it, but I really appreciate extra eyes. So, okay, I will make sure I review and remove those specific ones. So seeing that there were no public comments from the audience, or there's still none in the chat box, okay. Please let us know if anybody through the remainder of this hearing. Okay. So lastly, there are several measures I will need to adopt by motion and roll call vote, which is required by TCA 45222. So first, I will need a motion to adopt the hearing rules language as amended in the rules, and this includes all the amendments that we've talked about today. So that means the changes in authority that James has brought up to our attention, and then specifically removing of interior designers in that one specific section related to firm requirements. So I need the board, I need a motion, a second, and a roll call vote to adopt those rules.
So moved.
Got a motion from Mr. Alton Heathcote.
Second.
Got a second from Ms. Doss. And then with the rulemaking hearing, it's all roll call vote, so that'll be a little deviation from what we're used to. So I'll have to go down the pike. So it'll just be yes or no, all right, whether you agree or not. Jason Carter?
Yes.
Melanie Doss?
Yes.
Philip Lim?
Yes.
Blair Parker?
Yes.
Rick Thompson?
Yes.
Brian Tibbs?
Yes.
Frank Wagster?
Yes.
Dr. Ashraf El Sayed? And Jeff Nally?
Yes.
All right, thank you.
Next, I'm going to read the regulatory flexibility addendum. Pursuant to Tennessee Code Annotated 4-5-401 through 4-5-404, prior to initiating the rulemaking process, all agencies shall conduct a review of whether a proposed rule affects small businesses.
That's not on your list. I know you guys are looking for that. Those are just statements that GovOps requires as a part of a rulemaking hearing that we just adopt. They're sort of general blanket statements. My apologies.
So I'm going to read those statements into the record, and then I'll ask you guys to adopt them. The proposed amendments are not anticipated to affect small businesses, as the amendments are clerical in nature, and there are no known less burdensome, less intrusive, or less costly alternative methods to achieving the purpose of these rules. These rules do not create additional requirements for any license regulated by this board. So I need a motion and a second to adopt the regulatory flexibility addendum.
Okay. Got a motion from Mr. Thompson. Do we have a second? Got a second from Mr. Wagster. All right, for a roll call vote, Jason Carter,
Yes.
Melanie Doss,
Yes.
Philip Lim,
Yes.
Blair Parker,
Yes.
Rick Thompson,
Yes.
Brian Tibbs,
Yes.
Frank Wagster,
Yes.
Dr. Ash El Sayed, Jeff Nally. All right, thank you.
I will now read the impact on local government statement pursuant to Tennessee Code Annotated 4-5-228. There is no foreseen impact on any local government. I will now need a motion to adopt the impact on local government statement.
All right.
You have to vote on that.
Who was the, Dr. Ash was our vote for that one. Do we have a second from Mr. Tibbs? Jason Carter,
Yes.
Melanie Doss,
Yes.
Philip Lim,
Yeah.
Blair Parker,
Yes.
Rick Thompson,
Yes.
Brian Tibbs, Frank Wagster,
Yes.
Dr. Ash, Jeff Nally. All right, thank you.
So the next one is a little bit longer before you vote again, but I'm now going to read answers to the questions required by the Joint Government Operations Committee with the General Assembly. All agencies upon filing a rule must submit the following answers to these questions pursuant to Tennessee Code Annotated 4-5-226. So first, a brief summary of the rule and a description of all relevant changes and previous regulations effectuated by such rule. Answer. These rules address the retrospective review that was directed by the legislature and are mostly updates or cleanups intending to clarify current processes. These rules also contain definitions of the professions, which the board has spent many years debating, researching, and writing. The purpose of the definitions is to offer clarity to licensees and non-licensees on what the board considers to be practice of the professions of the board. Number two, a citation to and brief description of any federal law or regulation or any state law or regulation mandating promulgation of such rule or establishing guidelines relevant. There are no known federal, state laws, or regulations mandating the promulgation of these rules. Next, identification of persons, organizations, corporations, or governmental entities most directly affected by this rule and whether those persons, organizations, corporations, or governmental entities urge adoption or rejection of this rule. This rule will affect any licensee of the board since it defines practice and provides clarifying statements on various other aspects of the rule. We have not received word that any major groups or licensees would not want us to promulgate these rules. Identification of any opinions of the Attorney General or reporter or any judicial ruling that directly relates to the rule or the necessity to promulgate the rule. There are no known opinions of the Attorney General or any judicial ruling that directly relates to the rule or necessitates the promulgation of these rules. An estimate of the probable increase or decrease in state and local government revenues and expenditures, if any, resulting from the promulgation of these rules and assumptions and reasonings upon which the estimate is based. An agency shall not state that the fiscal impact is minimal if the fiscal impact is more than 2% of the agency's annual budget or $500,000, whichever is less. There is no foreseeable probable increase or decrease in state and local government revenues and expenditures. Next, identification of the appropriate agency representative or representatives possessing substantial knowledge and understanding of the rule. So I've given them two, myself, Laura Martin, Chief Counsel of the Tennessee Board of Architecture and Engineering Examiners, and Glenn Kopchak, Executive Director of the Tennessee Board of Architecture and Engineering Examiners. Identification of the appropriate agency representative or representatives who will explain the rule at a scheduled meeting of the committees. Glenn Kopchak, Executive Director of the Tennessee Board of Architecture and Engineering Examiners. I name myself, Laura Martin, Chief Counsel for the Tennessee Board of Architecture and Engineering Examiners. And then I'm also going to add Reed Witcher, who is the Assistant Commissioner for the Regulatory Boards at Tennessee Department of Commerce and Insurance. And then the next is the office address, telephone number, and email address of the agency representatives. And I have provided them. I don't need to read our phone numbers and emails into the record, but that will be provided to them. Any additional information relevant to the rule proposed for the continuation of the committee request, there is no known additional relevant information. I now need a motion to adopt the additional information for the Joint Government Operations Committee.
I move to adopt.
Got a motion from Mr. Wagster, a second from Mr. Tibbs. For roll call vote, Jason Carter,
Yes.
Melanie Doss,
Yes.
Philip Lim,
Yeah.
Blair Parker,
Yes.
Rick Thompson, Brian Tibbs, Frank Wagster,
Yes.
Dr. Ashraf El Sayed, Jeff Nally. All right, thank you.
Just one last check. Are there any public comments? Nope. Anybody in the chat box? Okay. This concludes the rulemaking hearing. Following this hearing, the rules will be held for additional comments following this hearing, the rules are going to be rerouted for approval through the department because there's a few substantive changes, but that should move pretty quickly since everybody's been involved the whole time with all the edits. And then I'll be putting this on the rulemaking filing form and submitting to the governor's office for final review, and then submitted to the attorney general's office for review and approval. Once the attorney general's signature is obtained, these are going to be filed with the Secretary of State and will become effective 90 days from the date of filing after they review for legality. And that's it. That concludes the hearing. Thank you.
All right, thank you. Chair, if we can just take a brief recess for our court reporter to collect her equipment, and then about 10 minutes, and then we'll come back here, if that would be okay with you?
Sounds good to me.
All right, so a brief recess then. Everyone will try to be back in our seats at 11:10. The word. All right, thank you guys. I appreciate a lot of big pieces. It was a big lift, so I'm just thankful that we've got that moving, and looking forward to seeing some progress on that front. So I know it's a lot of work, a lot of effort. So just very grateful to have that in the books. Okay. Looks like I've got a couple pieces. Oh, excuse me, Chair. I'm just running away, Chair, and you may have to shut this down. I'm getting out of hand. Are we returned to order then?
Return to order. Yep.
Thank you, sir. All right. If we may, then we'll go on and we'll hit the director's report. So we'll start with the budget, and then we've got a comedy application review policy, some edits there. All right. During our last review, we reviewed financial reporting through April. We currently have 2 more months of record. We're looking primarily at May and June. The only thing that jumped out at me was the technology line under June. That appears to be the result of STS charges due to the various projects and enhancements that we have them working on. STS is basically they're with Finance Administration. They're technology folks. They're kind of our geek squad for lack of a better term. For the state, and they bill us for anything that we put them on, and we've been putting them on a lot of core stuff. So we're always looking for ways to work more efficiently and effectively, and be able to respond to our customers, the public at large, and that requires to make sure that our public interfacing side of our shop, it represents you well and gives our customers what they need, access, to the information that they need, and to the board. So. We've been working on a lot of projects, and so Megan and Melanie just jumped right into that, and she's giving me more projects. She's brand new, and she's giving me projects, and so we're digging in, and she's been a real asset already, and very grateful to have her expertise. But that comes with a cost, and so that's what you're seeing there. I saw those itemized charges, and even at one point we had an admin person telling us that we had quite a few going, but we also have quite a few more boards too. So that comes with the ball game. But just for A&E alone, with 4 design professions, that's not the case in every jurisdiction, as you know. So with that comes the support for all of that. Let me just get a quick summary. You'll get a final sort of reconciliation. The close of our fiscal year, as you know, is June, but then we will reconcile all that and close it out. As you know, the invoices come in and have to be reconciled. So I'll give you a final number for all of that when we get to that point, as well as final reserves. But we are trending right now in surplus of $300,000, excess of $300,000 surplus. That's pretty good, and that's after our grants. So, Al?
Thank you. Given our surplus and the net accumulated value in our account, I want to reiterate again, particularly since hopefully we'll be setting the agenda for the October meeting, which will be our annual meeting, and the committees all meet, which should include the Budget and/or Finance Committee, I want to reiterate my request for the third year that we be allowed to increase the amount in the grants to higher education from our current $400,000 to $450,000.
Okay, all right, very noted. Anything else as far as that goes? Yes, sir.
Hey, Glenn, question, maybe I don't see the whole picture. What has caused us a big jump in the licensing revenue? Is that because we have more registered? Or?
Yeah, it's, we've actually been adding. I mean, everybody stalled out in 2020. The numbers even show that when you look at it. But everybody went back to work and it was roaring. This is one of the boards that's doing better than others. I mean, there's other boards. I'll give you an example. Real estate appraisers and home inspectors aren't doing as well. And that makes sense when you think about the market conditions. And so, people have their qualifications, but some folks won't carry a license in certain jurisdictions. A lot of our licenses are comedy as well, but they won't carry in those jurisdictions if they don't have work in those jurisdictions. That makes sense. And so,
okay.
Actually, I think the reason for that is because when we go out and talk to the different engineering universities and scare the fool out of everybody in there by telling them, look, we have a recession about every 12 to 15 years. If you don't have your license, you're going to lose your job.
Alton scared me the first time I went to one with him. I think was it Lipscomb that we were at? Yeah. And I thought I need to go get my PE license, and I'm not even qualified, but I was terrified.
Alton, just one quick thing about the grants. One reason we may want to request that additional money besides just the ability that we have to spend it is there's going to be an increased push for universities to have their professors become licensed, and maybe we could dangle that out there and say, hey, you can get additional money if you have a program not only to license your students but also to get your professors licensed.
And there's been a renewed interest in even our grants, as since we're talking about grants. Alton made the recommendation, you recall, from our last meeting to, at least put in a requirement for a proposal of at least, I think, 25%. Was that the number, Alton? Yeah. And so I haven't seen any of these proposals yet, but obviously that's a part of the requirement, which I highlighted in that email.
We probably ought to stipulate what the 25% was. It was to go towards the promotion of licensure.
Right. The FE in particular.
Yeah, it could be paying for the FE or paying for the architectural exam or doing classes or whatever. So
right,
probably should be more than 25%. But that I know and I clearly understand they need computer software, they need lab equipment, they need for the architects that go on their senior trips to different places, and it's all part of the curriculum, and we need to honor and respect that. But I still think we need to maintain a focus on the promotion of licensure.
Yep. All right, very well. Okay, so when I have, once we've reconciled this fiscal year, I'll share that with you at the next meeting, in our October meeting. And looks like for the comedy application review, if you can go there. In the past, we would just highlight a couple things, and I was like, well, I'm just going to do a red line so you can track all the changes. Otherwise, it would be chaos trying to sort that all in your mind. But it's really just it's just two buckets. Let me get there. All right, so on February 28, 2024, the board had a decision on comedy application reviews and reapplications. And so just to put that in your mind, I'll read the motions for both of those. This is 2/28/24, and if you want to go back to the minutes, comedy application reviews. Rob Barrett made a motion to grant administrative authority to approve comedy and model law applications where there exists an NCWS, NCARB, CLARB, or CIDQ certificate with record of satisfactory completion of the education exam and experience requirements per statute, the 3 E's. This was seconded by Blair Parker. The motion passed by unanimous voice vote. And so we're not talking about initials. We're talking about comedy, model law. You recall that. Initials that still go on the board, or when it's not clean. What we're saying is we don't need a rubber stamp, approval. If we've already had the authority themselves vet that, we were good for that to go out the door. That was the point in that conversation. However, we did have a comedy policy that was already on the books, and so we just need to make that policy square and comport with the decision that was already made in 2024, so everything syncs up. So that's what the attempt is here with the red line, because the comedy or policy that we had on the books before that board decision was limited to that tier 1 applications. You know, you're looking at pathway 1 for architects, model law for engineers, and no disciplinary action, which we qualified that there could be disciplinary action so long as it's outside 5 years, and there's been no changes to the status of that person's license as well. We discussed that last meeting, and so obviously that policy no longer was tracking with our board decisions and our progress and our evolution since then. So that's why we're here to address this policy, since it is on the books. And you'll also notice I didn't touch on landscape architects or interior design just because it wasn't part of the policy. It's not to exclude you folks. The board decision still stands. It's just for here, you weren't listed, so there wasn't any reason to address that at this point in venture. We may come back and get another bite of this apple later, but for now, we need to get a clean bill on this policy, and then something that we can work off of later if we need to. And so that's the whole point in doing this. So that's the first bucket. Then reapplications. That same meeting, Rob Barrick made a motion to update administrative authority to include reapplications for all design professions received within 5 years of the date of expiration instead of the previously approved 4 years. This was approved by Frank Wagster. The motion passed by unanimous vote. So we're touching on that as well, and you'll see that included. Yeah, because it says number 3. I'm adding the 5 years. You'll see that at the very bottom, number 3, making a recommendation, because that wasn't the decision. The decision was to, within that 5 years, which articulated was for us to move those from you, because no reason for our folks to wait. If they, again, a reapplication, they're already qualified. It's been within 5 years. There's no disciplinary action. Do we need to stall that applicant out? The answer back in 2024 was no, we don't. Let's just get them out the door. And so that policy now comports with that decision. And then the last piece, that's what all the red line is there. The last piece was just as a courtesy to our architects, and since Mr. Tibbs was going to be present, just to give them the opportunity to adopt the same language that the engineers adopted as it pertains to prior discipline. So 1A Part 4, it says no record of disciplinary action or felony conviction. Well, we're adding there, if prior discipline in another jurisdiction is at least 5 years old and the license was reinstated and remains in active status without restrictions in the same jurisdiction as the stated discipline, the applicant may bypass the application review committee. And so if that is still, I know at the time there was a sense to move forward and just add them as well, but since we're going to be chopping everything up, might as well just wait till today, and plus we have the benefit of having Mr. Tibbs here as well. So I'll let you look at that, but without reading it all in, you have the red line in front of you. I'll start with questions. Does anyone have any questions or concerns in regards to what you see before you? Yes, sir.
Glenn, I think I read through it, it's pretty well done, and I just want to kind of, since I just rolled back here, and this will show that we will not recognize the technology degree anymore, right?
Correct.
Because it's sunset, right?
That is correct. And that's why we have the statutory language in this policy. We're reiterating the fact that it's policies or pathways per statute, Yeah, there's no.
Thank you.
Yeah,
Thank you.
Absolutely. Any other questions or comments? All right. In that case, as the red line in front of you, we'll just need a motion to adopt that. Got a motion from Mr. Thompson. Do we have a second? Got a second from Mr. Tibbs. All in favor, please say aye.
Aye.
Any opposed? All right, hearing none, then we'll get that synced up and back on our website. I don't have anything extra for director's report, so looks like legal, it's your turn.
Well, we have 3 cases on for the legal report today. The first one is 2024-068381. In this one, the complainant is a certified engineer intern in Tennessee The respondent is unlicensed. The complainant stated that they were asked to provide a life safety plan for a local building that required a permit. After reviewing the drawings provided by the general contractor, they determined that the respondent was practicing architecture without a license. The complainant alleged that the respondent is engaged in licensed activity and that the drawings should require stamps. The respondent stated that they only advertised as architectural designers / drafters, which was explained to the clients. They stated that they worked with several structural engineers and disclosed that any portion of the design that needs to be reviewed and stamped by an architect or an engineer is the client's responsibility. For the project referenced in the complaint, the general contractor told them that since it was an existing building, no structural modifications were being made. They said that they were only modifying the exterior facade and non-load-bearing interior walls were being updated, so no stamp was needed. Additionally, the general contractor advised that the building was being divided into 3 units under 5,000 square feet with a firewall in between each unit. The respondent said that they took proper care, and if any portion of the project required an engineer, it was the general contractor's responsibility, and they have no knowledge of the actions taken. After review by a board member, it was determined that the respondent engaged in architectural services by subdividing the existing building with firewalls. There were no details provided that show how the proposed firewalls were meant to be designed. Additionally, subdividing the building doesn't create 3 different buildings and is still over 5,000 square feet, which requires design and seal of an architect. Despite the respondent's assertion that a structural engineer would be responsible for any relevant parts of the project, in this case, a structural engineer would not be permitted to stamp the plans. Based on the drawing index included in the document submitted, the respondent provided 13 drawings for the project, and it is recommended that the respondent be assessed $500 civil penalty per drawing submitted for practicing architecture without a license, so the total would be $6,500 for violation of Tennessee Code Annotated 62-105B, subsection 1. Any questions or comments?
I make a motion that we accept the recommendation.
All right, we've got a motion from Mr. Thompson. Do we have a second? We got a second from Mr. Tibbs. All in favor, please say aye.
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 Any opposed? All right, hearing none, then that one passed.
Good morning. For those I have not yet met, I'm attorney Scott Huddleston. This case, case number 2025-028711, involves a professional engineer. The respondent self-reported that they were disciplined in Wyoming in May of 2025 for providing professional engineering services on 10 projects without a valid business registration and for discipline in other jurisdictions. Wyoming noted disciplinary action taken against the respondent in 2024 in both Ohio and Missouri. The respondent was required to successfully pass a laws and ethics exam, complete a minimum of 3 hours of continuing education in ethics, and pay a civil penalty of $1,000 within 6 months. In October of 2024, as part of a settlement agreement with the Missouri Board, the respondent agreed for their license to be placed on probation for 2 years for failing to disclose discipline in Kentucky in their renewal application. This board issued a letter of caution on January the 24th, 2024, regarding the Kentucky discipline. Although respondent self-reported the discipline taken by the Wyoming board, respondent did not report the 2024 disciplinary actions in Missouri or Ohio to this board. However, none of the disciplinary actions taken by Wyoming, Missouri, or Ohio were reportable actions pursuant to Rule 0120-2-.075B, which requires registrants to report within 60 days if their license has been revoked, suspended, or voluntarily surrendered. Our recommendation at this case be closed with a letter of warning.
There it is, red button.
Sparring with those Casey.
He was also disciplined in Kentucky. Did he report the Kentucky disciplinary action?
Yes, well, actually, we sent a letter of caution regarding the Kentucky discipline.
Okay.
That was in 2023. That was issued, the letter of caution was issued in 2024.
Okay, thank you.
I move we approve the recommendation.
Second.
We've got a motion from Mr. Waxter, and we've got a second from, I didn't catch the second. Was that Dr. Ash? Okay, thank you.
Clarification.
What's that?
Clarification
Yeah, please,
question. So if this respondent hadn't self-reported any of this in the state of Tennessee, he would have done nothing wrong.
No, he's required to report, so,
But it just says that, however, none of the disciplinary actions taken by were reportable actions. So he's not required to report to Tennessee on those?
Well, if you look at Rule 0120-02-.7 regarding misconduct, paragraph 5, I'll just read that. A registrant may be deemed by the board to be guilty of misconduct in the registrant's professional practice if, in subparagraph B, the registrant's license or certificate of registration to practice architecture, engineering, or landscape architecture in another jurisdiction is revoked, suspended, or voluntarily surrendered as a result of disciplinary proceedings, or if the registrant fails to report such action to the board in writing within 60 days of the action.
yep. 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 No, that's a great clarification. So he is required to report. He's got 60 days, but so I thank you, Scott, for sort of ironing that out, though, as to reportable offenses. So thank you. All right, so we got a, yes,
I have
sir.
a quick question. I know letter of warning is much more severe than letter of caution, right? So what would get his attention, I guess, for future situation like that? Is the letter of warning strong enough? I mean, just a question.
Yeah.
Well, in my opinion, he has not committed any violation, therefore we cannot penalize him by any means. Therefore, I think the strongest action we can take is issue a letter of warning, informing him of his duty to report any future violations.
Thank you.
I'd like to add, I'm not sure that the vast majority of our registrants would know that if they had an issue in a different state, that they would have to come back to us and to tell us that. That's just me thinking out loud, but.
Is that a question in the renewal?
It is a question on the renewal. I mean, but I know what you're saying, Blair. You're talking about the 60-day time. Yeah, right. But yes, it is. We try to catch it in the renewal. So it's any character questions there or questions that would trigger a fresh start review like you had this morning. That's where we would do that. All right. So we've got a motion by Mr. Waxer to accept council's recommendation and a second by Dr. Ash. Any further discussion? All right. All in favor, please say aye.
Aye.
Any opposed? All right, hearing none, then that passed. We're ready for number 3.
The final case, excuse me, case number 2025-034-021 involves a professional architect. The respondent acknowledged on their renewal application that they had worked on several projects after allowing their license to expire. Respondent stated that they have worked on 7 projects in Tennessee since July of 2023 and further states, quote, one of the 7 projects is in a schematic design phase with exterior design elevations having been signed and sealed, but construction documents have not been solicited. The remaining 6 projects have completed permitting and construction As an additional level of oversight on these, I have gathered the project documents and engaged a Tennessee licensed colleague to review the construction documents to ensure they find these to meet Tennessee requirements. Upon my colleague's review, these documents appear to comply with Tennessee regulations. Upon further review of the project list, I would like to clarify that all 6 projects I signed and sealed construction documents for during the period which my license was expired were each business locations under 5,000 square feet in total gross area. As such, these projects fall within the exemption to require a licensed architect as described in Tennessee Code Annotated, Section 62-2-102. Our recommendation is that assess a civil penalty in the amount of $500 for each of the 7 violations for a total penalty of $3,500 and require the respondent to take and pass the rules and laws exam for using an expired certificate of registration in violation of Tennessee Code Annotated 62-2-105A1D.
I would like to move that we approve the recommendation.
We have a motion from Mr. Waxer. Do we have a second? We have a second from Mr. Tibbs. Any further discussion? Mhm.
Maybe help me understand that 6 of these were under the required 5,000 square feet. What's the violation?
Use of the seal.
He sealed them.
Yeah.
Yes, yeah. Correct.
Yeah. Can I make a comment on that? Thank you for bringing that up. We get a lot of questions about what the 5,000 square foot requirement is. And if you look at the regs, no one ever mentions this. The penalty, this was brought to their attention by Nashville-Davidson County. They informed her that her license had expired. And so, where I'm going with this is in that section, if you go to C, it says nothing in this section shall prevent any awarding authority, public or private, from requiring the services of a registered architect, engineer, or landscape architect for any project. This 5,000 square foot is not an automatic, you don't have to stamp it. Okay? That's first thing. And I don't know for sure, but anything I've ever done with them requires a seal. And they pointed it out, so I'm making the assumption that they were requiring it. That doesn't forgive the fact that the license was expired. But I think that people need to be very careful and try to understand that that doesn't give them the right to do anything they want to do under 5,000 square feet, not stamp it, my opinion. So, thank you.
Great discussion. Any other further discussion or questions? All right, so we have a motion by Frank Waxer and a second by Mr. Tibbs. All in favor, please say aye. Any opposed? All right, hearing none, then that passed. That's the end of legal.
Can I make a
Yes.
comment? So it seems like we, every month or every other month, seems like this is always the discussion. And, I know when we went and spoke at the Tennessee Engineers Conference last year, Alton made the comment that, look, this is what 95% of our discipline is because you've forgotten to renew your license. And I don't have the answer, but it seems like we ought to be trying to beat that drum a little louder somehow.
I think we do a decent job of notifying people when their license is due. We do send out information to them now, email, and I don't think we're doing it by mail anymore.
We still send out a card. We have done that. I checked on that recently with Megan to make sure it's still running. And so, when your renewals come up, you should get a postcard instead of the typical letter that everyone sort of files in the round file cabinet.
Right.
You know what I mean? We wanted something that will stick out, and so we borrowed that from another program. But yes, they're still getting appropriate notice, and so, obvious, and it is their responsibility to keep up with letting if they have an address change, that happens, you know, but it's still up to them. And to Mr. Thompson's point too, you know, when you're stamping something, then you're certifying that that's current. You're saying something with that seal. I'm qualified and that seal is active. I'm in good standing, you know, and you're not, you know, so if you're expired. And so it would be incumbent upon folks to keep. Now, I understand that becomes difficult when you're in multiple jurisdictions, but, you know, at the same point too, we do our part, and we go beyond the requirement to make sure we reach the folks that we can within the means that we have.
Go ahead.
Somebody's signing something as a PE.
Just need you on the record there because we're recording. Go ahead.
If someone is signing a letter as a PE without a seal, that's still the case. It doesn't change much if he seals it or not. He has an expired license. Some people probably don't know that or don't understand that.
I would encourage, I brought this up once before, of just with technology and communications, of having the respondents or licensees have their mobile number on file, and maybe eventually look for a reminder system that's automated through text. Because the email, the way technology is right now, email and even snail mail is not very reliable, but the ROI would be a revenue stream that's a much more reliable way these days.
I saw, you know, Megan works on our projects for our team, and admin, from which Melanie was coming from as well. They're testing across reg boards, basically a passport with the app, you know, and then so that's another stream of possibility that we could go. Now some of the, you know, the Cosmo and Barbers that are in mobile shops and stuff, that's really interesting to them because they need to have their stuff posted and be able to verify that. But then also for, you know, the security guards, they have to have their pocket card on them. Well, now they could just passport app it, you know, and so we're tracking that. And where there's application for us, then they're kind of leading the charge. They have a lot of folks over there, you know, in those areas. We have 20,000 licensees, 21, 22, compared to Cosmo Barbers like 80,000, and I think the security guards, that number fluctuates somewhere comparable to that, and so they're sort of, that's a nice beta test for us. Let them sort of kind of work that out, you know, in real time, and then if there's any application, we'll certainly track that and carry that forward to our program.
Several years ago, I was licensed in 22 states. That's a bear, okay? But I got either a written notice, a letter, or a card, just like a postcard, and it was my responsibility to you know, make sure that we were current in those states. And we had a rule in our firm that if we have a client and that client wants to do a project in Oregon, that do not do one single thing until you go check that spreadsheet, see who's licensed on that spreadsheet, and if it's not current, you go right away to that principal and say, what do we do? And then you get your license renewed. And in some instances, they may have gone over a year or something, and it's a lot more difficult to get it renewed. But you know, you got to do it. You got to be responsible for your license. It doesn't matter what state it's in, especially your home state.
Just out of curiosity, Rick, you said card and letter, but did you get an email also? How many of those sent emails?
Some send emails, yeah, but I mean, it came in a variety of, what I meant was it came in a variety of either the letter or it's like a postcard,
Yeah.
you know, and reminding you, and then some states would remind you multiple times. So, but thank goodness, you know. Funny thing, I was looking at NCARB the other day, and I was looking through the licensure, because when you renew your NCARB status or application, it asks you if you have recently either let a state expire or you're not practicing anymore in that particular state because it's listed. And so I said, well, let me go back and see which ones that I've let expire, because I'm retired from the firm. I'm not retired as an architect, but, those licenses have gone to another principal, and I'm not responsible for those anymore. And it had me that my license had expired in 2022 in Tennessee. So I immediately went to the IRS, and I knew it better than that, but I thought, now, why would they not know that? So there's, and that's, there. I don't know how many members are in NCARB, but why would they not know that if you're on a board and you're a member of NCARB that you are licensed or not? So it can get tricky. Yeah, so.
And just in case the public's listening to, not to beat a dead horse, but one of the reasons why that renewal is so important, sometimes we're like, well, it's just paperwork. Well, what's included that paperwork is attestation of your CE requirements and also character questions for which we did not pass somebody today because EP gave us a renewal in the engineers. And he was in violation of perhaps some fresh start, tenants. So that gives us an opportunity to look at somebody and see if they still meet the requirements. Aren't just the 3 E's. That gets you through the door. There's a certain you have to maintain those requirements, both character, CE, and so that's another reason for the. So if someone's listening to that and wondering like if it's just somebody didn't file their paperwork, well, it is much more than that. All right. Any more questions on the legal report or? Anything left from, does legal have anything that they need to add? All right. Thank you, guys. Appreciate you. All right. Then looks like we're, our committee report, we only had one committee today. That was Engineering Committee. You'll notice that on the agenda, we had 2 fresh start reviews and 1 application review. And then Mr. Collins, if you'd like to give that summary.
Like you said, we had the 2 fresh start reviews and the 1 disciplinary review, and we reviewed those and made appropriate recommendations to move forward or not with those.
Yeah, it was pretty straightforward. I mean, we had a lot to discuss within those 2 applications, but they dispatched that, and we made progress on all 3 and made a decision. So thankful to the committee for their work and asking some really good questions and keeping us on our toes too. We had folks on laptops on both sides of me pulling up information real time. So thank y'all for y'all folks at this table too for supporting the board in that regard. And all right, anything else, Mr. Collins?
No.
All right, thanks, sir. All right, do we have any new business? And then we'll of course have public comment, and then our chair can gavel us out after that. So do we have any new business? All right, hearing none then, this is the time for public comments. I'll go to the sheet while Ms. Griffey looks and see if there's anyone online that would like to speak. The only folks that signed in was our professional associations, and unless they wanted another bite of that apple, I think we can check the online then. Do we have anyone online? All right, hearing no one online or here present, we're closing out the public comment section. And so then, Chair, it's your prerogative if you feel like you would like to gavel us out.
We are adjourned.
All right, thank you, sir.
Yeah.